Good morning, everyone. My name is Matt Kaufman. I'm a partner with Hathaway and Coons over in Cheyenne, Wyoming. I'm also a governor appointee to what was the Wyoming Blockchain Task Force. Now it's called the Select Committee on Blockchain Technology and Innovation. Anyways, I'm going to talk to you this morning about securities law. Who doesn't want to learn about securities first thing in the morning? If we could cue up the slideshow. Okay, excellent. So this is going to be a general overview, kind of I've taken an approach of sort of the general practitioner that's relatively new to the space, that may be considering advising clients with respect to some type of an offering. And we're going to cover kind of the most common ways that offerings are conducted. Obviously, there's ways that offerings are conducted that I'll reference. We're not going to go in depth on today, but obviously, if there's questions, you all have been informed or will be informed, I guess, of the instruction process afterwards, or can reach out to me regarding specific questions. So with that, let's get started. This is just kind of a quick roadmap of what we're going to talk about today. I'm going to go over sort of the securities regulations and issue spotting. I try to incorporate some practice tips for attorneys who, again, are new to this or maybe have done it for a little while but are trying to learn more. So we'll start off with discussing who regulates these types of situations and when, common ways that companies are raising capital, including both federal and state exemptions. And then I'm going to spend a little time, if we have time, at the end talking about some unique opportunities in Wyoming, given what Wyoming has done in the past several years with some legislative initiatives. We've got some, what I think are some exciting new ways that companies could look at raising capital that are unique to Wyoming. So first, we'll start by talking about the regulators and who are the regulators. So generally speaking, and there's of course exceptions depending on some of the nuances of activity, such as broker-dealer activities and different intermediary or custody activities. But generally speaking, at the state level, at least in Wyoming, the regulators of securities offerings is the Secretary of State. And that covers, in my mind, two areas. One, which is what practitioners often refer to as state blue sky compliance. And that's in reference to federal exemptions or federal offerings that have a state component where you need to file some sort of a notice or ensure that on a state-by-state basis, you're still compliant. And then there's intrastate offerings where the offering occurs solely within the bounds of a state. Again, those are governed and regulated by the Secretary of State's office. So we're going to talk about those as well. And then at the federal level, of course, the primary entity is the Securities and Exchange Commission. And for today's purposes, we're going to make a distinction between two different types of offerings. One, which is a registered public offering. And we're not going to talk a lot about that. It's important to understand, I think, the context of public offerings as sort of the backdrop of being a general rule, and then how those relate to what will be the primary topic today, and that is exempt private offerings. So let's start with the default rules, and I'm going to talk about this both at the state and federal level. But the default rule for the state, for Wyoming anyways, and it's pretty uniform across the states. There is a Uniform Securities Act that has been adopted by most states. But that general rule is you cannot offer securities for sale generally unless the security is registered. So you have one of those registered public offerings. The security is a federally covered security. So in other words, the ones that have a federally imposed exemption, or the security is exempt under state law. And we're going to talk about specifically some of those state exemptions under Wyoming. I left a Wyoming statutory reference for Wyoming practitioners that may care, but there are a few specific state exemptions. We're going to define them. Most people have at least heard of the Howey case, the famous case that set forth the test that we use still to this day to assess whether or not something is a security. And what a lot of people don't understand is, of course, that the statutes and regulations, both in Wyoming and federally, define what a security is. But within that definition of a security, there's a broad term called an investment contract. And an investment contract is more or less what securities regulators have used to be a catch-all phrase. And there's been a tremendous amount of case law and analysis over what is included within that term, an investment contract. And so that's kind of where, at least in my mind, a lot of new instances of securities case law and sort of particularly so in the blockchain crypto space, a lot of the guidance that's been put out by the SEC and the analysis has been done under this term, whether or not something is considered an investment contract. Just a reminder, though, I mean, investment contract can refer to equity or debt. We're going to talk about that today. But generally, the definition under the Howey test is an investment of money where the investor has an expectation of profit from the efforts of others. The actual Howey definition is slightly more nuanced than that, but that's my boiled down summary of the definition. A practice tip I have here is that this is incredibly important to understand, and I think every practitioner that's working in this space should have a pretty good working understanding of the Howey test and sort of the nuances, at least at a high level, of what an investment contract can be. You know, one of my partners that I practice with in this area, and I talk about it a lot, but we see many deals where we think practitioners and business people alike are unknowingly, engaging in the sale of securities because they haven't taken the time to understand the context, and they haven't taken the time to really do the analysis or understand what that analysis is. And so it's an important issue to be aware of, because failure to spot that issue early on can certainly create liability for the issuer being the company that's making the securities offering, or the attorney or attorneys that are working on the matter. If securities are offered in a manner that's public or go through a public market, which is, as we know, our public securities exchanges today, which give rise to liquidity and public sale rights and things like that, the security generally has to be registered as a public security. And there's a number of reasons that companies will go through that effort, and that is, you can generally solicit the market, you can openly advertise, you can widely broadcast the availability of the security to any class of investor. The securities can be bought and sold anytime, so there's obviously a liquidity premium. And then, wider market acceptance. Again, it's available for lots of different types of investors, and there's easier on-ramps for people to put capital into public securities. There's cons of public registration, though, too, and the cons can weigh heavy for a lot of companies. It's a very expensive process. Doing an IPO, getting a stock listed for public registration is a very lengthy and expensive process. It subjects the issuers to really intense scrutiny and regulation. I had a conversation just not too long ago with a former SEC agent who was telling me a little bit about some of the work that he did in IPOs when they would go back and examine and look at some of the private offerings and the conduct of companies leading up to the IPO, and that scrutiny can be very intense. And then the last is that it creates numerous protections for investors, as well as liability pressure points for people running the company. So, not every security obviously is fit for public registration. And that's why so much of the capital activity in this country, where they're not interested in pursuing that, falls under the category of what we call private placements. And so when I say private placement, I'm just simply meaning a capital offering done pursuant to an exemption from the requirement for registration. Oftentimes when I talk to my clients, I refer to this as an exemption pathway. We have to find a federal or state exemption under which we can complete an offering in a way that's compliant with either state or federal securities laws, or maybe both, and do so in a way that can complete the objective to raise the capital. So the most common areas, and this is just kind of a high level right now, we're going to dive into all these areas, but Section 4.2 of the Securities Act sets forth the general exemption for private placements. practitioners and most people in business know these types of exemption pathways as being Reg D or Regulation D offerings. And there's really three primary types that are, at least for discussion today, and that's Rule 504, which we'll go through, Rule 506B, and then 506C. There used to be a 505 exemption, which no longer exists, and I intentionally have that on there and have it struck out because I continue to be amazed at the securities practitioners that still talk about 505 as if it exists today, and I'm not sure that some of them are aware that it doesn't any longer exist as a viable option for a Reg D offering. So important thing to take note of. Then there's Regulation CF crowdfunding. So this is federal crowdfunding, as we often refer to it. And this is a relatively recent creation of the Jobs Act a number of years ago. We'll talk about some of the pros and cons of that. And then Section 3A11 governs intrastate offerings. And within intrastate offerings, we have the category of state exemptions. And so for today's purposes, of course, I'll be focused on Wyoming specific methods of these intrastate offerings. Wyoming, of course, was the first place in the country to enact a utility token mechanism, which is a state exempt offering. Wyoming has a statute called the WIN statute, which well, I was going to make a joke, but I won't. It stands for Wyoming Invest Now, and it's a state interstate crowdfunding mechanism. And then Wyoming has a state exemption for small offerings, which we'll talk briefly about as well. So I want to just kind of give a little bit of context, and this is very imprecise, but for those that might be new to this space, I want to talk about the process from a practitioner's perspective, more or less. And when a client or a company is discussing the need or the idea of evaluating a capital raise or going out and finding investors, what does that process look like? And typically that discussion usually starts with, it starts with what type of entity are you? Are you a corporation? Are you an LLC, a partnership? How is this offering going to be structured? So in other words, what's being offered? Are we going to offer equity? Are we going to offer debt? Is it going to be through a document called a SAFE, which stands for Simple Agreement for Future Equity? We'll talk a little bit about SAFE agreements and their increasing use. But we have to have an understanding of, first and foremost, what it is that's going to be offered. Secondly, then we have to identify the exemption pathway. At least that's what I call it. And I have another practice tip here. And I really, really believe strongly that this is an important thing for practitioners to do early. Again, I can't tell you how many times we field calls at our firm from companies or clients who have this idea that they want to raise money. They may or may not be sure of how they're going to do it, and they call us and say, "Hey, we just took our first $100,000 from an investor. What do we need to do to make this legal?" Well, so first of all, you've already made the offering, and you've already closed your first deal. So at that point in time, we're going to have to reverse engineer and make sure that it was compliant. So it's really important, to the extent that as a lawyer you have that input, to make sure that before money is accepted, you have a clear understanding of what the exemption pathway is, so you can guide your clients on what they can and can't do. Another practice tip here is something to keep in mind for all securities laws, whether it's state or federal. There are general prohibitions on bad actors from participating in securities offerings. Now, firms take a lot of different approaches to how they screen out bad actors. Some have questionnaires that they may give their clients. And, I'm not going to go into the nuances of how the SEC defines a bad actor, but it's basically someone who's been convicted of a financial crime or a crime of dishonesty or something that might automatically disqualify them from being eligible for a securities exemption. And again, there is some onus on the attorney to make some inquiry into this. Now, again, like I said, some firms take the position that they'll give their client a questionnaire or ask certain questions. To be perfectly candid, I haven't gone that far. For us, it's usually some initial due diligence on our own accord, and maybe some conversations about the company's principles and their background and experience. I want to stress that point, that there is a threshold issue to determine, to make sure that the people you're representing aren't bad actors. And then the preparation of documents. So now you know what's going to be offered. You know generally how much your client's going to go for, what the exemption pathway is going to be. Now you can start to, hopefully your client's already got a business plan, some key documents. So you can incorporate that into a private placement memorandum. Some people will use purchase documents, subscription agreements, and then of course an area or a component of these closing documents that can't be understated are the disclosure documents. And obviously disclosures are generally incorporated into a PPM or a private placement memorandum or purchase documents. But however you do it, you need to make sure that disclosures are made. And we'll talk more about disclosures and some general guidance on that. But the general idea is, an issuer needs to make disclosures of material fact to the investor so that they can make an informed decision. And that includes not omitting material information as well. And you can't be misleading. And there's general rules, but by and large, if companies are honest about what their product or service is, what they're going to do with the money, how they're going to capitalize, and they're not misleading about the market or the opportunity or the potential, usually you're in pretty good shape. Then the next step is the companies have to, of course, find investors. And this is a very, very big one, which of course relates back to the early discussions of what the exemption pathway is, because the method for finding investors is going to be very dependent on the exemption pathway. So for a lot of the offerings that we're going to talk about today, there's a ban on general solicitation. In other words, you can't be out broadcasting this on Facebook, social media. You have to rely on what the Federal Act refers to as a pre-existing relationship. So in other words, your friends, family, your existing network. The Jobs Act changes brought forth new opportunities for issuers in this respect, because you can now generally solicit. But with general solicitation comes some trade-offs, and that is there's limitations on who can invest, and there's also some requirements placed on the issuer, and we'll talk about those. If it's a federal offering of some sort, there's generally a requirement, if you're going to operate within a safe harbor, that you have to file a Form D. Generally speaking, those Form Ds are due within 15 days from the start. So that's an important timeline to know. And then state blue sky compliance. So, you may have a company that does, I'm going to say, for example, a 506C offering. You'll file the Form D federally. As you make offers in particular states, different states have requirements with respect to what they require. So that's what we're referring to there as state blue sky compliance. And then obviously the clients would close the investment deals. Again, you better have good documentation, make sure that the clients are executing all the appropriate purchase documents and disclosures. And then this process can be repeated as necessary. Obviously, we often talk in the startup and corporate world about companies doing rounds of financing. And so this process can be repeated. We're not going to talk a lot about it today, but something that I want to raise the issue of for practitioners, you need to be aware of something called the integration doctrine. And so there's a general safe harbor with federal offering exemptions that if you have more than 180 days between the end of one offering and the start of the next, that's considered a safe harbor and the offerings can't be integrated. If it's less than 180 days, offerings are subject to integration from the SEC, where, in other words, the SEC could come in and take both rounds of the offering, integrate them, consider them as one, and now both offerings have the obligation of being able to comply with whatever exemption pathway. This can get really complicated and really tricky because different exemption pathways have different requirements. And so it could be that the risk of integration means that you're no longer compliant. So again, something to be aware of, something to understand, the factors that go into integration doctrine and consideration, and what you should be aware of. Some key considerations. Again, this is primarily for practitioners more so than companies, but who are thinking about doing an offering. You've got to understand, of course, right away what amount of money is going to be needed. the type of the security. Again, like we talked about, if a subsequent investment round is anticipated or expected, that's not always known by every company at the outset. Of course, everybody thinks that they know exactly how much money they're going to need, and rarely do they. It's going to depend upon the financial strength of investors. So if you're not familiar with the term an accredited investor, you need to get familiar with that term, because it's a very important concept within securities laws, and we're going to talk about that here in just 10 seconds. And then the existing network of possible investors, of course, as we talked about, that method of how companies will go out and approach investors is really important. This has got to be part of the consideration for what the method is, primarily dependent upon, does there need to be general solicitation? In other words, do we need to broadcast it to the world to find investors, or does the company or the issuer have a sufficient network that they can raise the capital from people that they already know, or their pre-existing network? So a key concept that we're going to talk about a lot with all these offerings is an accredited investor. This stems from Rule 501 at the federal level. And generally speaking, I'm going to ignore my notes here for just a second, but generally speaking, there's some nuances, a lot of nuances actually, to what an accredited investor is. But institutional investors are generally accredited. Individuals with $1 million liquid net worth. So for purposes of calculating the $1 million net worth, you cannot include your principal residence. Or you can also get there by having $200,000 or more a year of annual income, or $300,000 or more with your spouse, and then there has to be a reasonable expectation of that continuing. There's some other considerations that can go into the accredited investor definition, but those are kind of the big ones. However, I want to point out that just in the last 60 days, the SEC has announced some brand new changes to the accredited definition, which has not happened in a long, long time. So this is new, and they're not effective yet, but they will be soon. And I'm not going to go through this in detail, but generally speaking, the accredited investor definition has been expanded to include certain people with education surrounding financial interactions and instruments. So people that hold Series 7, Series 65, Series 82 licenses can automatically be accredited investors regardless of their net worth or income. People that are knowledgeable employees of a fund or something like that. It also has expanded to include LLCs with certain assets, family offices with certain assets, and then it also adds the term a spousal equivalent. So if one individual, or I should say one spouse in a marriage is accredited, the other one can tag along, so to speak, as an accredited investor as well. So, a good expansion. There's been a lot of chatter over the last several years about whether or not the accredited investor definition should be changed to increase those limits, because the $200,000 income, $300,000 income, $1 million net worth haven't been changed in a long, long time. But so far, it looks like those are going to stay the same. So now we're going to get into the specific offering types and the exemption pathways that are commonly used. The first one, which is not one, to be perfectly honest, that I've used a lot, but I'm not sure why, and that is Reg D. It's a 504 offering. These are generally thought of or referred to as kind of seed round or small round exemptions. There is a limit of $5 million that you can raise in any 12-month period. There's no specific limit on the number of purchasers, and there's no specific disclosure requirement, which is one of the reasons that this exemption pathway does get utilized a lot. Now, that doesn't mean you're out of the anti-fraud or material omission requirements that we talked about. And I know a lot of practitioners still take the approach that even though there's no specific disclosure requirement set forth, it's still best practice and a good liability shield to go ahead and, of course, still make disclosures to the extent that you can. Otherwise, the 504 offering has the same restrictions on resale. And generally speaking, I want to speak about that for just a second. Generally speaking, for all of the offerings that we're going to be talking about today, there are resale restrictions. In other words, the security that an individual purchases has to hold it for a certain amount of time. It's not intended to be a liquid security where it can be bought and sold freely on a market. So there has to be resale restrictions. And this 504 offering would be another one of those non-general solicitation offerings. So this is just existing networks. 506B offerings are oops, hold on, sorry. 506B offerings are kind of the traditional way that money was raised. This has, for the past many years been kind of for sure the most widely used safe harbor exemption. There's no specific limit on an amount of money you can raise in 12 months. Again, no general solicitation is permitted. It's limited to 35 sophisticated purchasers. I'm not going to go into this right now. The regs set forth sort of some guidelines with respect to how you vet someone as being a sophisticated purchaser. Basically, you have to try to nail down that they've got sufficient experience, expertise, education, that they can gauge the risks for themselves. And then accredited investors, you can have an unlimited amount. Basically, the accredited investors are not counted as investors for this exemption pathway. I do have a practice tip in here because this is talked about a lot amongst securities attorneys. But again, the disclosures required, it's a little bit gray, because if you only had accredited investors in a 506B offering, there's not a lot of specific guidance on what you have to give them. Again, general practice is good disclosures, material information, can't omit any material facts, nothing misleading. But if you have non-accredited, generally speaking, those disclosure requirements are heightened, and you have an obligation to give them, things like audited financials and more specific disclosures. What ends up happening in offerings where you have both accredited and non-accredited, again, generally the policy of the law is if you're given information to non-accredited, you better give it to the accredited as well. So in other words, give the same information to everybody. There's no reason not to. This again, like I mentioned, for the past many years has been by far the most common amongst the Reg D offerings. I think it's a useful, pretty versatile offering mechanism. The SEC reported, and this is kind of an old statistic, a couple years old, but over 90% of all the exemption filings were 506 offerings. So again, really common, popular way to do it. So again, I've kind of beat this to death already, but I'm going to keep hounding it because it's an important concept. The old rules, like under 506B, you could not generally solicit for these offerings. As an example, you had to go with that pre-existing relationship. The manner of the offering had to be conducted in a private way. But now we have these new rules with the Jobs Act changes. Federal crowdfunding was enacted. So with federal crowdfunding, an issuer can generally solicit, but it's there's still a lot of limitations on the offering under Regulation CF and federal crowdfunding. There's limitations on the amounts that you can raise. There's individual investor limitations. There's requirements to use pre-registered portals. So the requirements and the trade-offs for having general solicitation can be steep. The other one, though, that's really quickly changing the landscape of private offerings, and that is under Reg D 506. Now there's a subcategory of C offerings, and 506 C offerings are similar to B, except that general solicitation is now allowed. The catch is, though, that you can only accept investments from accredited investors, and the issuer has to take on the risk of verifying or certifying that the investors are accredited. So this is a big change because under the old statute, under 506B standards, the issuer can rely on what they call a reasonable basis to believe that investors are accredited. So a way that's commonly vetted is people might use investor questionnaires. You might have seen something like that, where you can sort of self-certify that you're accredited or that you have the requisite sophistication. Under 506C, though, that's heightened. The rules suggest that you have to have copies of tax returns, a letter from their lawyer or their accountant, or something that again verifies or certifies that they're accredited. So it's certainly a heightened standard. So the specifics of the 506C offering. Whoops, I keep skipping ahead. Again, it's sort of a recent upgrade to Reg D. There's no limit on the amount raised in a 12-month period. It does allow for general solicitation, which is new. There's no limit on the number of purchasers, but the purchasers have to be accredited. And again, I sort of talked about this already, so I won't repeat it, but you got to verify that purchasers are accredited. You still have to abide by all the other Reg D requirements. In other words, the securities are still restricted. You still have to file your Form D, got to make proper disclosures, all that kind of thing. But this is really quickly becoming, again, I've referenced one of my partners here that he and I do some offerings together. And I remember, 2 or 3 years ago, we were really hesitant to kind of start these because the general solicitation ban has been so well enforced and such a bright line rule for so long. I think a lot of lawyers like myself it took them a little while to warm up to this idea, but this is becoming a very commonly used exemption these days. I'll talk for just a little bit about crowdfunding. This is in the federal context. So Title III of the Jobs Act set forth how you can go about crowdfunding. So again, crowdfunding, people use the term crowdfunding for a lot of different things. Remember things like Kickstarter, those platforms where they're doing what I call product-based crowdfunding, where you're essentially pre-selling a product. That's not crowdfunding from an equity standpoint. That's not, this kind of crowdfunding because they're not issuing equity. They're not issuing a securities instrument of any kind. They're just pre-selling you something to raise some capital with a promise to deliver that. Crowdfunding is selling, a security. Regulation CF, though, you can really only raise about $1 million. It's an imprecise number. I think it's like $1,070,000 over a 12-month period. So it's not a huge amount of money. It has to be done through a broker-dealer registered funding portal, which there's not a ton of out there. You still have to generally comply with state securities laws. There's restrictions on individual investors. I didn't want to waste the time to go through it, but there's a whole formula. If your net worth is below $100,000, you can only invest, I don't even remember the numbers off the top of my head, but it's like 2% of your net worth. If it's over $100,000, it's up to 10%, but not until you get to a certain limit. So there's a lot of rules with respect to how much individuals can invest. And the problems with Regulation CF that I hear and see a lot are the cost of the capital. It's costly to do one of these offerings. The reporting requirements, limits on investors. It's definitely a cost benefit analysis, but the trade-off is you can take investment from anyone, accredited or not, regardless of where they are. So there is, of course, still some benefit to it. Some more new rules. States have begun. Well, this isn't really a new rule, but it's becoming more commonly used, at least in our world. States have begun to more commonly use what was previously known as the intrastate exemption. The theory of intrastate exemptions, for those that may not be familiar with this, is that if an issuer is based in a particular state and all of the investors are in that state and your operations are in that state, then you're not really engaging in interstate commerce such that it would invoke the jurisdiction of the federal government, i.e. the SEC. And so in those instances, your state regulator then can retain control of the authority and jurisdiction over those offerings. And so what Wyoming did a few years ago, which a lot of other states have done too, Wyoming's just taken theirs kind of to the extreme, and that is the creation of something called the WIN program, which is an intrastate crowdfunding mechanism. I threw up a little chart here that I won't go through, but the WIN program creates this equity-based crowdfunding, and essentially the process, which I'll summarize in this chart, is you as an issuer have to create the proper disclosures, offering mechanism, purchase documents, work with the Secretary of State to get that approved. Once that's approved, the offering can essentially then be registered with the Secretary of State and generally solicited. You can publicly broadcast that offering. You have to be a Wyoming entity. You can generally solicit. The offers can be viewed by anyone, but the purchasers have to be Wyoming residents. And again, there's a little bit of a heightened requirement placed on the issuer that you have to provide documentation or evidence of the fact that the purchasers are Wyoming residents. We have a little practice tip here that obtaining written representation from a purchaser on in-state residency is probably not enough. You got to have, so again, getting back to that reasonable belief standard, you probably need something more than that. And so we, of course, recommend to our clients that you, maybe it's a copy of a driver's license or something, but you got to take some steps to try to verify that they really are in-state residents. So real quickly, how these win offerings work. We have two different tracks in Wyoming. If you don't want to do audited financials, you can raise up to $2 million. If you do audited financials, you can raise up to $4 million. The maximum amount each person can buy, it's up to $10,000 if you're non-accredited. And again, Wyoming doesn't have its own definition of accredited. This is the Uniform Securities Act, the federal definition of accredited that we talked about. And then you can invest any amount if you are accredited. So that's why, again, I mentioned the definition of accredited, because the federal definition controls here. But I want to take note here because changes are on the way. As I mentioned at the outset, I'm a governor appointee to the Wyoming, what was the Blockchain Task Force, now the Select Committee. And we just passed a bill through our committee, which will go to the Wyoming legislature this next session, that brings changes to all these limits. So obviously this is not law yet, but the changes, and I actually, myself and one of my partners sort of wrote the bill here, but the proposal on the plate, at least the bill right now, would up the minimum, or I should say the lower track, to $3 million from $2 million. And on the audited tract, it would raise it all the way to $15 million. So a very, very large jump. That puts Wyoming way ahead of any other state in terms of its intrastate crowdfunding limits. Similarly, on the non-accredited investor amounts being at $10,000, Wyoming's proposal in this current bill is to raise those limits to $35,000. So again, big jumps that make this offering potentially a lot more attractive to a lot of companies. Keep in mind, there's still some other requirements on disclosure, portal requirements, things like that with intrastate crowdfunding. But generally, this is the outline. I want to make just a real quick comment because we're already getting down to only 20 minutes left. I'm not going to talk today. There's a couple of big offering types out there that are well used. I'm not an expert in these offering types. One of them is Regulation A. There's a new version called Regulation A+. These are often referred to as mini IPOs. Regulation A+ has a couple different tracks. You can raise, I think, up to 25 million under track A and up to 50 million in the higher track. But there's a registration process. You get these offerings approved with the SEC. Once they're approved, though, you can go out and generally solicit and take them to sort of, not an exchange traded market, but take them to market. And so this is a very, very real and good, useful tool for a lot of companies that are looking to raise a substantial amount of capital. We just don't happen to see a lot of them here in Wyoming. And then Regulation S is for foreign investor offerings. And again, being in Wyoming, we don't do a ton of these, but I wanted to mention those to everyone because those are exemption pathways that people should just be at least aware of. And then I'm going to quickly cover a few other offering types. So under our Wyoming Securities Act, Uniform Securities Act, we have a couple of unique offerings, the most notable of which is, and I have the statutory site there for any Wyoming practitioners that care, but we have something called the small offering exemption. And that exemption allows an issuer to raise capital from not more than 25 purchasers in 12 months. There cannot be any general solicitation. There can't be any commission on solicitation other than registered broker-dealers. And you have to have some reasonable belief that purchasers are acquiring for investment. And there's, a lot of the common disclosure requirements that we've already talked about. But for, little companies that are just looking to raise a little bit of money from a few people, and you're confident that it's going to stay intrastate, this is a viable exception. Now, I don't have a practice tip on here, but the practice tip I would give a lot of people is that I still know a lot of practitioners that might say, even if we're going to use this, what would be the harm in treating it like a 506B or a 504 and going ahead and filing a Form D with the SEC? Just it's kind of belt and suspenders. It also gives some flexibility in case you have an investor come along that's not inside the state, or there's some other consideration that you might not think of. It's usually not that onerous to do both, but this is a great fallback position to know and to be aware of, and so something that clients and companies should be aware of. The key point to remember, though, is disclosure is key, and we always pound this into our clients' heads that regardless of the offering type, you got to disclose the key risks. You've got to disclose, what the equity structure is going to look like, what it is they're buying, what the valuation is. It's just any key information that you would want to know, you got to disclose. I pulled an example of some disclosures that we use in our WIN offerings. These aren't necessarily WIN specific, even though this was used for a WIN offering. But these are the types of things that you have to get extensive risk acknowledgments and disclosures from. You want your investors to acknowledge that they're investing in high risk speculative business ventures, that they could lose all their money, that the securities are restricted, they're illiquid, there might be tax consequences. I'm not gonna go through all of them, but I wanted to take a minute to kind of highlight the fact that the disclosures are really key, and we tend to emphasize that with our clients, and we spend a lot of time making sure that those disclosures are as good as we can reasonably make them, because at the end of the day, that's your best liability protection. So a few more key points to remember. All securities transactions, even exempt ones, are subject to anti-fraud provisions of the federal securities laws. This means, you as a company, you're on the hook for false or misleading statements. And as a company, it doesn't matter if it's orally or in writing. If you're misleading people or making false statements and you're not correcting it and allowing them to invest under those pretenses, you have potential liability. And the government enforces securities laws through a number of ways. It could be criminal if it's really bad. Could be civil or even administrative. And then private parties also have both state and federal remedies. A federal law cause of action that's often talked about is a 10B action, and there's a private right of action. Our Wyoming State Securities Act has some private rights of action with very specific remedies, including things like rescission, where investors are entitled to get their money back. In some cases, it can even be money back plus an interest rate or plus attorney's fees. In some instances, there's actually room for punitives. So again, this is where the rubber meets the road in terms of why those disclosures are important, why finding a proper exemption pathway is important, because the remedies here are very real, and it's not just regulatory risk, it's also private risk. And the more investors a company takes on, the more broadly they solicit investors, the greater that risk becomes. And so companies need to be prepared to try to mitigate that as much as possible. And then this is, I should have put this at the outset where we talked about the bad actor disqualification, but there are disqualification provisions under Reg A, Reg D, Reg CF. We have some similar type provisions under our State Securities Act that talks about disqualifying certain people from being able to participate in these types of exempt offerings. And usually those are people that are convicted or subject to court administrative sanctions for securities fraud or crimes of dishonesty and things like that. But again, something to be aware of, because I've counseled many companies that got into securities offerings and discovered that one of their officers or one of their directors had some sort of a background or a history, and that can create real problems. And so something, again, to be very aware of. More key points. Generally, issuers have to inform purchasers that the securities aren't registered and that there's limitations. And again, I'm not going to go through this specifically, but we've all probably seen it if you've looked at any private investment documents. There's usually some type of a legend talking about the restrictions on the securities. That's there for a reason. It's required. So if you're doing offerings, make sure you take the time to understand what those are and that those are included. I'm going to talk about this just for a minute. These are kind of some of the key instruments that are used for capital raising. Obviously we always talk about stock, as an equity interest, whether it's common stock, preferred stock, or, whatever type of splits that companies use. There's LLC membership interests. We often do that through purchase agreements. Partnership interests can be the same. Debt, convertible notes, convertible note instruments, for those that aren't familiar, it's typically a promissory note with a conversion right by the note holder to convert that debt into equity. Generally, those notes usually accrue the interest, and there's usually some sort of a discount rate on the price at conversion, and that discount's usually used as an incentive to the note holder. But there's a lot of reasons that convertible notes are used, and one of those reasons is it allows companies early on in the process to kind of punt on that valuation question. When you're selling somebody equity, you really have to have a good handle on what your company value is going to be for purposes of figuring out the equity piece that you're selling. Notes, you don't have to do that quite so much. You can punt on that issue a little bit. And the other reason is that some investors just like the idea of being a creditor early on as opposed to being an equity holder, because if the company goes down in a ball of flames, you're in line before the equity holders are in terms of getting capital out, and they like that. And then the third type, which I mentioned, is becoming more and more popular, and that's the SAFE agreement. It stands for Simple Agreement for Future Equity. SAFEs are not equity. It's an agreement that the investor will be granted equity based on some triggering event. Usually there's conversion terms kind of similar to a convertible note. There might be a discount rate or other incentive mechanisms. There's usually repurchase rights. There's usually dissolution rights. There's usually voting rights in certain circumstances. So, SAFEs can take on a number of forms, but it's sometimes a very quick, easy way to get an investor into, a position with a company without necessarily having to negotiate all the specific terms that might go along with an equity ownership interest. And so, again, it's really popular. Though I want to dispel, because I've had a number of clients ask me this, if we do a convertible note offering or a SAFE offering, that's not stock, so it's not a security, right? Wrong. It's very clear under the Howey analysis, and the SEC has time and time again been very clear that all of these constitute investment contracts. They're all securities. They're all regulated. So if you're doing any of these types of offerings, you have to be concerned about those exemptions. Real quickly, we've got a whole lot of other presenters today. They're going to spend their time talking about the nuances of digital assets. So I'm not going to spend a lot of time talking about that, but federal securities laws still require, the same type of compliance for digital assets. And again, I'm not going to go through this in detail, but I was just telling this story to someone the other day, and it makes me feel, I guess, kind of good about myself. But like I've mentioned a few times to my partner that he and I do a lot of securities offerings. We were part of that craze in 2016, 2017, when we were receiving calls like crazy from clients with this great idea that we want to raise money by issuing some tokens, some sort of blockchain token. We want to do it this thing called an ICO, an initial coin offering or a token offering. And these things aren't securities. They're not regulated by the SEC. So will you help us drop some documents? And very quickly, my partner and I were looking at these things going, no, they're securities. You can't do that. We can do it, but we need to have all of the stuff that we're talking about here in mind. We need to find some exemption pathway. So we jokingly sort of pat ourselves on the back saying, we were calling these things security tokens before the security token was even a phrase, before it was an industry term, because we were of the opinion long ago that, any token offering, any offering of a digital asset that's not for a utility or consumptive purpose really probably is a security. And so there needs to be some securities compliance component or analysis in conjunction with that. That's all I'll say. Like I said, I'll leave the rest to the rest of our presenters. But I do want to real quickly talk about Wyoming's unique token offering, and that is, within the digital asset structure, we talk again about a couple different types of token offerings, security tokens and utility tokens. The utility token craze has kind of died off, but I mentioned here the SAFT. The SAFT was a nifty invention to sort of take the idea of the safe and apply that to tokens. But what I want to specifically mention here is that, again, while I'm not going to talk about security tokens in depth, Wyoming was the first state to enact a utility token exemption. And it's here's the statutory site in case anybody cares to look it up more specifically. But it's basically an open blockchain token exemption. If you're the developer or seller of a blockchain token, it can be deemed to not be a security if you got to file notice with our Secretary of State. It's got to have a consumptive purpose for goods or services. You cannot sell the token to the initial buyer as a financial investment. You can't market it as a financial investment. And then there's some factors there that the issuer has to believe to be true. You can't. You have to reasonably believe that it's for a consumptive purpose. The consumptive purpose has to be available at or near the time of sale. The initial buyer of the token has to be prevented from reselling the token until the token is usable for that consumptive purpose. And then the developer has to take reasonable precautions to prevent buyers from buying them as a financial investment. And so, again, this was a really hot topic 3-4 years ago. It's died off in my mind. Although I think we're seeing a little bit of a resurgence of now that the industry, the digital asset industry, has kind of sort of acquiesced to the idea that, okay, we thought we were not securities and we could evade securities laws, and now they're all coming around and recognizing, because of all the SEC enforcement actions, that we are securities. So generally, we're going to fall into that securities token bucket if you're raising capital, unless you're going to try to be a cryptocurrency or something that's truly not a security. It might be more like a commodity type that's regulated by the CFTC or something else. But we have this other bucket called this utility token that still is available in Wyoming. I've heard lawyers take different approaches on this. My personal take is that the only way under Wyoming's law that you can do this in a safe manner is to do it as an intra-state offering. So again, Wyoming has taken the position that if you can do a utility token offering in this manner, that it's deemed to not be a security. No other state has passed a law quite like this. There's a number of states that are looking at it. There's a few states that have passed some different things, but so the second, again, that you cross over state bounds, in my estimation, you're now engaging in that interstate commerce that we talked about and subjecting yourself to the SEC's interpretation of this, and that gets riskier. So, anyways, but I did want to spend a little bit of time talking about this because it is today under Wyoming law a viable mechanism to raise capital through a token offering. Like I said, it's not being real widely used because I think the industry has sort of acquiesced to the securities idea, but nonetheless, it's there. Sorry, I didn't realize I had one more slide on utility tokens. There's a few other restrictions on the utility token offering here in Wyoming and things that the issuers have to do. The only thing I'll highlight here is that bottom point, and that is under Wyoming's law, we call them open blockchain tokens, and they're defined as a digital unit which is created in response to the verification or collection of a specified number of transactions tied to a digital ledger by using computer code or network to track, using either a digital ledger that's decentralized and mathematically verified and capable of being recorded and transferred without an intermediary or custodian. So that's sort of a complicated and lengthy way of stating what sort of the state of the art is, I guess. That's sort of an open blockchain token defined right there. And so again, for practitioners that are wading into this area, I think it's necessary and important for them to take some time to understand just a little bit about this technology. No lawyer necessarily has to be a master of the technology, although there's some out there that are, and it's impressive. But at least understand what it is if you're going to undertake one of these token offerings, what it is fundamentally that your client's doing and how they're doing it, because you need to be able to make sure that it meets the statutory requirements. I wanted to talk just for a few minutes with our last couple of minutes about issue spotting. The presumption again of token offerings is that they're securities that's regulated, unless they're being offered for consumptive purposes. I already talked a little bit about Wyoming's utility token statute. Likely works for intrastate offerings, but you take that interstate and that gets dicey. Nationally, the SEC has shut down a number of offerings, even those that claim to be a utility token. The SEC has famously come down pretty harshly on some tokens that thought they were classifying themselves as a utility token. And initially, there was a general rejection, by the ICO market of SEC regulation, and this did turn out to be a big mistake, like we talked about. There are ways I'm seeing practitioners be very creative with respect to layering sort of securities offerings on top of these token instruments. Of course, the security token mechanisms now being placed. Wyoming has also, I don't have a separate slide for this, but Wyoming has also taken the initiative in its corporate statutes to allow companies to issue their shares on a blockchain. And again, I've counseled some clients on that just because shares or some representation of corporate value is put on a blockchain, in no way, shape, or form gets you out of a securities analysis. It still resides squarely within that securities analysis. So again, just issues to be aware of. With that, I think I've covered everything. Sorry for the cheesy slide. I love that show, and of course, I've sat through a lot of pitches with companies trying to sell their investments, and have helped companies do it. And so, this is an area I'm passionate about. It's fun to see companies get out there and raise capital. Please feel free. Anybody that has questions after this, feel free to reach out, follow up. There's going to be a portal put up online for some live Q&A after this is over. So I'll be hanging around for a little bit. Feel free to hang around and ask some questions. Thanks a bunch.